Scott Reynolds. I'm the team leader of the Reynolds team here in Vero Beach, and I have an awesome guest. Probably many of you guys know him, but Jordan Lulich, who's a local real estate attorney here in town. Thanks for making it out.
Yeah, appreciate you inviting me again on the podcast. Always enjoy the conversation with you, Scott.
Yeah, so I wanted to kind of, I think on the previous one we talked a little bit more at a higher level, and today what I wanted to talk about are some maybe a little more specific about specific transactions that where an attorney came involved into the transaction where two realtors are or only one realtor was. And was able to help them navigate through some of the contractual obligations of either party.
Sure.
So I guess first of all, for those who don't know who Jordan is, tell us a little bit about yourself.
Sure. So my name's Jordan Lulich. I was born and raised here in Vero Beach. I graduated from the charter school. I'm a double Nole, so go Seminoles. And so after growing up here, honestly, I thought it was God's waiting place for somewhere bigger and better. Couldn't wait to get out of here. And when I went to Tallahassee after being away for a long time, I was like, wow, this place, Indian River County, it's not too bad. You can fish, you've got the beach, you've got the water. And that's the aspects that I really miss. So I decided once I graduated and passed the bar, I moved back here, started practicing. Started practicing my first year, just multiple different practice areas. But instantly, the things on the calendar that I enjoyed the most were real estate. So it was a no-brainer for me. Get rid of the things that I don't enjoy practicing and focus my practice on real estate.
Right.
So my practice is primarily real estate and estate planning. And I represent sellers, buyers, real estate brokers, team leaders. And I enjoy it because when you think about real estate in other areas of the law, real estate's something tangible. It's something you can touch, something movable. It's one of the deepest constitutional rights that we have in the United States. And so for me, that's where my passion is. So it's been great. And these last couple of years have been interesting because since I've started, the market really picked up these last couple of years. And seeing how sellers and buyers act, it's part law, but almost part psychologist almost, because sometimes people are not acting rationally. They're speeding up to put properties under contract. And sometimes we just got to slow down and really consider what we're getting into before our client puts a property under contract. So it's a little bit about me in a nutshell.
Yeah, you've been helpful for us for a long time, and even before that. So we really appreciate it. You've helped me out with just organizational agreements, organizational contracts, and also obviously with our buyers and sellers of helping them out as well. So I appreciate it.
Yeah.
So I thought, who better than Jordan to kind of dig into some of the reasons why we may get an attorney involved in a transaction. First of all, it is kind of easy up front when you're writing the contract to have an attorney review or have you look over a contract. That's usually the easy one,
right? Like
where you're in it, in the very beginning,
right? That's what I prefer,
right? And buyers and sellers are all moving fast and on the weekend, and honestly, just to be 100% candid, 90% of the time, a lot of them are going just totally well. But I want to talk about some instances like where there is a conflict between the buyer and seller.
Sure.
Or a conflict in maybe the title that we've just recently ran through that you've helped us through, and I thought it'd be a great way of sharing with somebody else.
Sure.
So the one was where we had someone that had deceased. There was someone that wanted to sell a property, but the original owner was deceased, and then they went through some interesting ways of conveying their property rights to another person. It wasn't a family member; it was actually a significant other. I don't think they were married at the time.
Right.
And we took we did the listing and everything, but then you were able to help us out with, actually getting into where it was marketable.
Right. And so, that comes down to there's 3 different ways that you can take ownership to a title of a property. So when you take title in Florida as husband and wife, we call that tenants by the entirety. So you and your wife own a property, you pass away, Scott, your wife will automatically become 100% owner of the property. All that we really need is a death certificate to be recorded just to show that you passed away.
Right.
Very simple, seamless. That's an automatic transition upon your passing. The other two forms of ownership, one is similar to husband and wife, and we call this one joint tenants with right of survivorship. So it operates the same way as husband and wife, just the only difference we have is it's not tenants by the entirety because there's no marriage that's required for this one. So in order for joint tenants with right of survivorship, on the deed of the property, it actually has to say joint tenants with full rights of survivorship. It can't say joint tenants.
Right.
Which is what we saw.
We ran into that with another one. Yes. Yeah.
So we saw a title to the property. It said joint tenants, and that was not valid.
And background for the crowd or the audience, the property owner had a Connecticut real estate attorney prepare the new deed, and in their area, I guess one reason or another, it wasn't to Florida standards. So having a Florida real estate attorney do it to our standards is a big difference maker.
Yeah. And I mean, everything we talk about, I mean, we're talking very general today. And so none of this is intended to be legal advice.
Right.
And so if I'm dealing with a client who has a property in a different state, I'm giving the same advice. You should talk to an attorney in that state because I'm only licensed to practice in the state of Florida. And again, from a transactional standpoint, I think we can assume that this conversation is based upon the November 2021 as-is contract,
right,
for this conversational standpoint.
Right.
But every specific transaction is going to be a little bit different.
Right. That's the attorney disclosure.
It's the fine print.
That was a huge help, and I think everything's going well on that now.
Yeah.
It's just a little bit of time delay, and we worked out something between the buyer and seller to just postpone everything.
Right. So if you don't have husband and wife, and if you don't have joint tenants with full rights of survivorship, what that means is then you take ownership to the property, tenants in common. So if you and I own a property together, we don't clarify that we own it joint tenants with full rights of survivorship, then it means you own 50%, I own 50%, and we own that as tenants in common. What that means is if you pass away, your 50% interest goes to whoever you leave your assets to, your heirs. Same for me. So if there's no clarification in the deed, then it's presumed to be tenants in common. That's why how you take title is so important.
And with rights of survivorship, if you and I own the property, there would be no question if I were to pass, you would own the property 100% without my heirs.
Automatically.
Right.
Yep.
So that's the difference in a few words on a deed.
Yeah. Huge impact. Yeah.
So that's something to keep mindful of. And I don't expect everyone to memorize these type of things, but it is important to have your agent know when the red flags are there, and the sooner the better to get an attorney involved. So,
and like you said, Scott, I mean, most of the time transactions don't go wrong, and a lot of times an attorney is not even needed. But where we start seeing attorneys needed is, one, if there's a title issue, or two, if there's custom verbiage that's starting to be added to the contract. That's where I see a lot of transactions go south, because it's not supposed to be written by an agent or a buyer or a seller. That's really where you have an attorney needing to draft that specific language.
And that's a good point. And the contracts that are already in place are approved by, I don't want to exaggerate and say hundreds of attorneys, but an attorney body, with legal review already pre-built in. Often, like, I have to show buyers and sellers their extra concerns that they just want written into the contract. I slow down and I show them in the contract where that's already addressed.
Right.
And that's one way of keeping the specials, because there really shouldn't be tons of special stuff.
No, there shouldn't be. And I mean, so the contract's reviewed every 2 to 3 years. It goes through a very extensive review of real estate agents, of attorneys. And so, the 12, 13 pages of that as-is contract, it's going to contain a lot of the necessary items that people may want to feel more comfortable adding in, that it's just not necessary. It's already added in there.
I want to jump into like a rapid fire. I don't want to put you on the spot, but I do get asked often, and again, this is not legal advice. I'll say it for him as well. people that buy investment properties
Okay.
and they are getting a mortgage.
Okay.
Some places they say, like these investment gurus are like, you want everything in an LLC.
Right.
Why should someone have it in an LLC versus like I don't know if it's a bad thing or not, but like my personal properties are in my personal name.
Yeah.
But I don't know how the lenders a lot of time don't.
So you've asked a loaded question. So let me respond at least why LLCs are important. So I had a client. I can't go into any specifics to protect the innocent, but the client owned 5 properties individually. So similar to you, Scott. So at one of his properties, he rented them all out. He had tenants at all the properties. At one of the properties, one of his tenants was having a birthday party. And at that birthday party, there was 30, 40 people over the house. They were having a good time. They were drinking. But then amongst the party surfaced a pistol. And that pistol was loaded. So what do you think happens with a bunch of people drinking and with the loaded pistol being passed around?
Accidents.
An accident happened, exactly. And that gun misfired and it shot a little boy in the shoulder. Thankfully, the little boy's okay today. Mm-hmm. But his parents, rightfully so, were absolutely furious that he was shot at that party. And so those little boys' parents went to an attorney. And the attorney said, you should sue. So who is the attorney going to advise to sue?
Everybody.
Everybody.
They do. They do.
Well, it depends who you ask.
The tenant.
Deep pockets.
Yeah, right.
So not the tenant, because the tenant doesn't have any money, right? So the landowner, the property owner.
Right.
Right? So my client there owned 5 different properties.
Which puts a bigger target on their back.
Yeah. And so his exposure in that example is all 5 properties were at risk. All 5 rental properties and everything else he owns.
Okay.
So you transition those properties into an LLC. Let's say his 5 rentals then go into an LLC. Little boy's parents go to see an attorney. Attorney says you should sue. Who should you sue? The property owner. Mm-hmm. But now that your properties are in an LLC, the little boy's parents would be suing the LLC rather than my client individually.
That particular one too.
That particular one. So in that example, if he had 5 properties in the LLC, then his liability is those 5 properties in the LLC. So ultimately, you're limiting your liability to something that arises out of a property that's in an LLC to whatever's in the LLC.
Right.
Right? Your LLC sued, the risk is whatever is in the LLC.
And the first thing they're going to go after is the insurance.
Right.
Because they have liability. It's right there. Right. It's an easy target.
Right.
But if they can't get what they want out of that, well, they probably attack the whole thing. Everything.
Yeah, correct.
And then whittle it down to what they can get.
That's why property insurance and umbrella insurance policy, it's important to have that necessary coverage.
Spare like little tangent is actually part of the major increases of insurance. It's not the hurricane coverages. It's really the liabilities that attorneys and people are suing. All the getting money out of the liability companies.
Yeah.
So
yeah, and there's a lot of fraud, fake claims going on.
That's why.
Yeah, it's a large problem we have here in Florida.
So.
So that was the first part of your question. I don't know if that answered it as why LLCs are important.
It answers it why, but now the part you may not know, and which it just let me know, is the LLC. I wonder if the individual can apply for the credit and apply for the, a brand new LLC.
Yeah.
It may have a hard time getting a mortgage.
Right. And so sometimes clients purchase an LLC in their individual name, and then they come and ask me, hey, can I transfer my property, my investment property, into an LLC? Right. But they may have a mortgage. Mm-hmm. So every single mortgage contains a due on sale clause.
Right.
What that due on sale clause means is essentially if you transfer your ownership interest in the property, then the mortgage company has the right to accelerate and demand that the entire mortgage is due. Mm-hmm. So I get asked, can I transfer my property into an LLC? Practically speaking, we very rarely see banks enforce this due on sale clause for transferring it into an LLC or trust. The times that we do see the due on sale clause enforced is if the borrower stops making payments, if they stop keeping the property insured, if they fail to pay taxes.
Negligent on their duties.
If they fail to do the necessary things that they said that they were going to do in the mortgage, then we see that the bank's looking into the file and we see that, oh, wow, they're actually transferred this property and they're 6 months behind on their mortgage. We're going to require that the entire mortgage is due.
And that is actually easier. Now I'm thinking through.
Yeah.
That's easier than probably a foreclosure action. They've actually have a default in their note.
It'd be similar.
Yeah.
In order to take back the property, it would have to go through foreclosure.
Okay.
So I was talking with a practitioner and another attorney about this last week, and he said in his 40 years, he's never seen a lender enforce the due on sale clause for just transferring it into an LLC.
So that's been the only thing that's ever held. I'm just speaking firsthand. I always think it's cool to be authentic. Is the whole ambiguity of the relationship with the mortgage company and the due on sale clause.
Yeah.
So,
I always advise clients about it, but from a practical standpoint, other practitioners, we don't see that being enforced. The other aspect is insurance, right? Because then you go from an insurance policy for yourself personally to an insurance policy for your LLC, which might be a little bit more costly.
It's not too bad if you're, that's not a reason, or I don't think it's a reason, because you're already saying this is a rental property. Now, if the person's trying to say it's their second home or stuff like that, that may be different.
Okay.
But if you're saying this is my investment property,
Right.
here's 25% down, give me an investment type loan.
Okay.
It's the insurance is usually rated about the same.
Yeah.
So that's what we've seen in the marketplace. One more last legal type situation with no legal advice. Had a recent situation that we kind of looped you into the email where we had a title. We had a closing that was in progress and title came back and there were some judgments and some HOA payments that hadn't been made and some things where title needed to have a little bit more time to get how much is owed,
right,
and some judgments.
Right.
And so it turned out to be, I'm giving some of the background, where the buyer and the seller was acting as though the buyer's just being late or tardy, and the buyer was rightfully concerned about clear title.
Right.
And we found in the standard language, and involved you, of course, on curing title and that. Can you talk a little bit about that?
Yeah. So when you sign the as-is contract as a buyer, one of the features of the as-is contract is that when you purchase the property, the seller's agreeing to deliver marketable title to you. So the conversation becomes is what is marketable title, right? Mm-hmm. Marketable title is something that you can freely alienate. It's something where there's nothing that encumbers the title of the property, right? Mm-hmm. And so what this means, to kind of break it down even more basic language, is it means that you're not purchasing a property that's subject to an existing mortgage. It means that you don't have a judgment that's encumbering the property, where if you go to sell it to someone else, there's no previous judgments that are against the property in which you have to pay off. So in the situation we saw that there was a judgment that was levied against the property that had to be paid off before closing. And absolutely, that's one of the main purposes of the as-is contract, is to take title to the property where it's marketable, where you have clear and clean title, right? With a judgment, you don't have clean and clear title. And so within the contract, what it says is if for some reason that there's a defect, if for some reason there's an issue that prevents that title from being clean and clear, then the seller is given an opportunity to try to resolve it, right? We call this the cure period. So they're given typically 30 days as the default to take the necessary steps in order to resolve whatever defects there are. So if it's a judgment, that could mean obtaining a payoff in order to get the amount of the judgment. Right. That could mean contacting necessary people in order to understand what to do to pay that off.
Because getting the payoffs are not just easy. There's a judgment amount sometimes, but then there's accrued interest.
Right.
So in order to make sure it's truly a clear title, down to the penny, down to the day of closing, they have to get a payoff from the attorney, whoever placed the judgment, or HOA, so that they can settle up at closing.
Now, I think we may have had this scenario, you and I, Scott, but I had a previous question that was asked where it was, I forget, I'm going to make up the amounts, but it was a $500,000 property, but there was a $600,000 IRS lien that encumbered the property. So I got called up by the seller, and they said, can we negotiate the judgment and lower it so we can sell the property and put some cash in our pocket? And I said, well, you may be able to negotiate that lien, but I have very little doubt that you're going to negotiate it down to a point where you're going to be able to put money into your pocket. Because if a judgment holder has a judgment and they see there's equity in the property, then why are they going to negotiate it down? They may negotiate it where the property could be sold because there's some motivation there. And so that case, we didn't see that being cut in half. We saw it maybe being cut to a point where it could cover closing costs, and then $0 would be going to the seller.
You know, that one I remember, and what was great between the agent and the attorney, that we were able to get where the seller was able to pay off most of his debt, and actually got the because it was IRS, got the U.S. Attorney's Office involved, and he signed a new note for like the balance. It was like $100,000 difference, but at least the debt, a lot of the debt could get satisfied, and took all the equity out of the property, which is all the juice they were going to get. And then all they had to do is chase around. I'm saying it the wrong way, but chase around $100,000 from the individual. You know, where at least that.
So it was a partial release.
It was a partial release, and where we were able, but it was because, quite frankly, the agent did so much upfront work with the in helping them dig through their records and everything. And then getting the legal advice was a big help. But that was another one. We couldn't say we could say we weren't going to sell it, but that wasn't going to solve his problem. And we could have gave the buyers their earnest money back and everything. But he still would have had the cloud of problems.
The cloud of title.
And so we weren't going to be able to find another buyer and resolve it any differently. So that was. So I guess what I wanted to do, everyone always hears about the highlight. I call it the highlight reel, the slam dunks, the big sales, but there's a lot of details that get done and a lot of problems that get worked through by very competent agents and legal professionals. And I think the combination of the two have a lot of power. And I couldn't think of anyone else to bring in. Is there anything else that you think would be relevant not to put you on the spot?
I mean, Scott, you know me, I could keep talking if you want me to. But I mean, another example that we previously saw was with the deceased donor, right? And so something that I always tell anybody is, if you're inheriting a home, that's typically not going to be an automatic process. Typically, it's a process in order to obtain ownership for a home from an aunt, uncle, mom, dad, someone that you're inheriting it from. So a common mistake that I see in transactions is properties that go under contract that become listed on the market, but the necessary steps in order to actually list it in the correct way are not done. So we get to this position where there's a buyer, we've got a contract, but we can't close on the property because a probate may have to occur. The biggest advice that I can tell an agent, a seller, a buyer is have a proper estate plan in place. So important. One of the most difficult and complex cases that I've had to date is a lady who passed away, no will, no trust, no estate plan, nobody here, no family here, and she had 15 distant relatives throughout Europe. And so we have to go through the process of trying to identify, try to locate, and some of these heirs, they only receive 1/42 of an interest in this piece of property that we're trying to sell, right? 1/42 of an interest. So we found 13 out of the 15 of them, and 2 of them are not responding. So we have to file a lawsuit to force the sale of this home.
And not that you need more complexities, but what if you got one of the 42, one of the 15 are passed away. You got
then you have to probate their estate.
Wow.
I know. And so we can avoid all of this complexity. We can avoid all of this delay by having a proper estate plan. So estate planning and real estate, they intersect so much because if you don't have a proper estate plan, then you could have problems trying to sell your real estate down the road.
Right. Wow. So that's so I still think the key is it's going to be impossible for the consumer or the buyer or seller to like know all the details. Right. But I think we're working with trusted people that do it often. I always like using the analogy, like if you have a loved one that's going to, hopefully never have to, but have to have brain surgery or something that's super, super important. You want them with a surgeon that does 300 of them. Right. Not the one that does 10. Right. And so the people, the practitioners that are in it every day, doing it every day, know how to resolve the problems, have the resources, I think and resources are experience, knowledge, or connections. Right. I believe is imperative. So working with a good real estate agent or team, and obviously a great attorney cannot be a waste of time.
Well, Scott, I really appreciate you having me on again today.
Yeah, love having you. No problem. Thank you.
All right.